Session we are going to see about the quasi-contract. Quasi-contract means there is no contract, but the law presumes that there is a contract, and the law gives some obligations to the parties. It presumes that there is a relationship between the parties. There is no offer, acceptance, consideration, nothing. No relationship because of the contract, actual contract, but still the law presumes the contract is present and it imposes some obligations on the party. It presumes that there is a relationship between them. The quasi means as if. That is, the law presumes the relationship as if there is a contract. The law puts some obligations on them as if there is a contract. This is quasi-contract. The word quasi is not used in Indian contract. Indian Contract Act does not have the words quasi-contract. But it has a separate chapter with the heading certain relations resembling those created by contract. Certain relations resembling those created by contract. The words itself gives the full meaning of what it is meant by that. It is the quasi-contract is mainly for avoiding the unjust enrichment by some people. For example, if a person gives by mistake leaves something in one person's house, and if that person enjoys that is unjust enrichment. He has to give it. For example, one person by mistake put a basket of apple in one person's house and that person used it. Then the person has a legal obligation to pay for the things he has used it. There are 5 sections dealing with the quasi-contract in Indian Contract Act. Section 68 to 72 deals with this. Sections 68 to 72, each section with the 5 different situations. Section 68 deals with the supply of necessaries. It deals with the supply of necessaries to the persons who are incompetent to the contract. For example, a minor cannot enter into a contract. He cannot get something on credit from somebody. So a person may provide it. This section 68 deals with the situation where necessaries are supplied to the persons who are incompetent to a contract or to the persons who are dependent on the persons who are incompetent to the contract. For example, there may be a lunatic person. He cannot enter into a contract. He may have a son, wife or daughter, a family to support. If that is the case, a grocery merchant may provide some rice and other items to the family of the lunatic person. He can claim it from the property, from the assets of the lunatic person. There is no contract, still the law allows the person who has supplied the necessary to the lunatic person to claim from his property. In the same way, there may be a minor. A person may be spending money on his education. He has a right to claim the money. That the law uses the word reimbursement. He can get the amount reimbursed from the property of the minor. So, for necessary supplied to the persons who are incompetent to contract such as minor or lunacy or to their dependent, the amount can be reimbursed from the property. 2 things to be noted. It is no personal liability for the minor or the incompetent person. Only the person has a right to claim it from the property of the person who is incompetent to the contract. That is only from the property, no personal liability. Second, what is necessary is to be decided by the court. The English court has a ruling that the things supplied should be of necessary item, and the person who has availed it, who has got it, should not have the item at his stock. For example, a person may have a rice in his house. A further supply of rice may not be regarded as a necessary. Even though rice is a necessary item, still if he has a rice in his house, then rice need not be taken as a necessary item. This is regarding supply to the supply of necessary to the minor person. Next is the payment by interested person, section 69. An interested person may make a payment on behalf of other person. For example, a person is residing in a house as a tenant. The house owner has not paid the house tax. Municipal authorities at his doorstep threatening to initiate actions, threatening to close the house, seal the house. Then the tenant may pay the property tax. So there is a demand for the money. This person has paid even though he is not liable to pay. He is paying on behalf of the other person. In that case, the money has to be paid by that person. The landlord has to pay the money to the tenant who has paid the tax on his behalf. This is section 69. The section says, a person who is interested in the payment of money which another is bound by law to pay and who therefore pays it is entitled to be reimbursed by the other. The tenant who has paid the property tax of the landlord has the right to receive the money. There are some conditions for this. The payer must be interested in the payment. Only the person who is interested in the payment of money is having the right to get the reimbursement. That only the tenant can pay. The neighbor of the tenant cannot pay and get the reimbursement. The person should have the interest to pay. In this case, the tenant is in urgent need to pay the money, otherwise the municipal authorities will initiate action and his stay at the house may be affected. Next is, the payer should not be bound to pay. It should be the liability of the other person. If the payer is also bound to pay, then he cannot claim it. In the same example, if there is an agreement between the landlord and the tenant has to pay property tax, in that case he cannot get a reimbursement. Third one is, payment should be to the another person. It should not be by the same person. For example, in one case, a government authority was a tenant of a house and they have adjusted the rent towards the property tax, but the court held it is not correct. It should be payment to the other person. Next is, the payment should be legally, there should be a legal compulsion to pay. In the same example, if the case is going on between the landlord and the municipal authority, there is no legal compulsion to pay unless the court decides about the case. In that case, the tenant should not make a payment. So the conditions here is, the payer should have an interest. Otherwise, if the payment is not made, he is affected. So he should have an interest. He should be the legally bound to pay. The other person should be legally bound to pay, like landlord should be legally bound to pay the tax, and it should be to the third party. Next is the section 70. It deals with the liability to pay non-gratuitous act. If something has done not to be done in a gratuitous, non-gratuitous act, there is a liability to pay. For example, one person came and by mistake delivered a basket of apple in the house of another person. This person has taken the apple and consumed it. That means he has taken the benefit. In that case, he has to make a payment. This is section 70. Where a person lawfully does anything for another or delivers anything to him for not intending to do so gratuitously, and such another person enjoys the benefit thereof, he is bound to pay a payment. That is, three cases: lawfully does anything or delivers anything, the other person has enjoyed the benefit, not intending to do so gratuitously. For example, a contractor constructed a building for a government. Sometime later, then the government says, we don't have a power to enter into a contract with you. There is no contract. The contract already entered with you is void because the person has no right to enter into a contract. In that case, the government has to reimburse a person because the contractor has not done the job to do gratuitously. He done only for money, and the government has enjoyed the benefit. In that case, the government has to make payment. There are conditions, essential conditions. It should be lawfully done. The act should be lawfully done. There is a case, Indu Mehta versus State of UP. District collector appointed an advocate as a public prosecutor, and she was there for 2.5 years. But the government has not confirmed it, the appointment. The appointment not ratified by the government. After 2.5 years, government intimated that appointment is not valid. So the money was not paid. She approached the court. Court held that she was there for 2.5 years. She did something. You have enjoyed the benefit of her services. You have to pay. It is legally done. Then it should be non-gratuitous act. A person suddenly there was a fire accident. A person helped the person to rescue something, and he helped in that fire accident activity. Then it is a gratuitous act. Unless otherwise it is shown he has done it for money. Next, enjoy the benefit. The same example already we discussed about a delivery of one basket of apple. The person took it, he enjoyed it, then he has to make a payment. Same example, the contractor constructed the building, government enjoyed it, then government has to pay. Next, choice to reject the services. It is also another condition. The person should have the choice to reject it. By mistake, a basket of apple was placed in the house. The person has a choice to reject. He should not have taken it. He should know that it is not for him. Then if he knows that it is not for him, he should not have taken it. He should not have consumed it. Once the choice is given, he should say that it is not for me, I don't want it. But without that, if he has enjoyed the benefit, he has to make a payment. Then the fourth one, finder of lost goods. Section 71 deals with the finder of lost goods. It gives the right as a bailer for the bailee for a finder of lost goods. For example, there was a cow. A person took it. He tried to trace out the original owner. He could not see that. Get in contact with that person. Cow is there. He spent money on the feed for the cattle. So it some time goes, and the money he has spent he can recover from the original owner. The rules are, he has a right to, as a bailee, he has a right to retain the goods till he gets the money he spent on that, like the maintenance of the goods, like in this case feed, cost of feed for the cattle, cost of expenses to trace out the owner. He has a right to retain the possession of the goods till he gets the money. 1. He has no right to sue for the expenditures. He cannot file a suit for the expenditure. 2. Third, if there is a reward, he has a right to sue for the reward. He can claim the reward in the court. Then the law gives a right to sell the property under some conditions. If the goods are perishable, he can sell it. For example, what he has found out is an unclaimed basket of tomato, then he cannot keep it for some more time, only 1 or 2 days. Within that he can sell it. If the item is a perishable, the finder of lost good can sell it. Number 2, if the expenditures is more than 2/3 of the value of the asset, then he can sell it. In the same example, the person was feeding that cattle, that cow for some time, and the cost of the feed and the amount spent on tracing the owner exceeds 2/3 of the value of the cow, then he can sell the cow. This is a finder of lost good. Then the fifth one is mistake or coercion. Any money received by mistake or under coercion has to be returned. By mistake, it may be mistake of law or it may be mistake of fact, the money has to be returned. In one case, sales tax officer Banaras versus Kanhaiya Lal Mukuntlal Saraf. In this case, they have paid the sales tax, thinking that they have to pay, they are liable to pay. Subsequently, there was a High Court case in another company. There the High Court clarified for this item you should not collect the sales tax. The government was prohibited from collecting sales tax for the particular transaction. So this company again claimed the refund. The government said money paid cannot be returned because it is a mistake of law. But the court held under this section, even the mistake of law or mistake of fact should be returned back. Any money received by mistake has to be returned. If somebody gives money thinking that he is another person, then that person has to return it. By mistake did anything, then it has to be returned. Same is the case when coercion is there. For example, this coercion is not as per the contracted coercion. Even a small pressure is called coercion. For example, a person wanted to take delivery of a goods at the railway station and he was in urgent need of the goods, but the railway company was demanding more money. Instead of 100 rupees, he was demanding 500 rupees. What that person will do? He will pay 500 and claim the money because he has paid under coercion. The person was under pressure to pay because he is in urgent need of money. The other person is telling, unless otherwise you pay 500 rupees, I will not give you the money. So the money is paid under coercion. This has to be returned back. These are regarding coercion. With this we close this chapter.